So if I could have your attention. This is a special evening. Once every year we come together as a community to celebrate one of our own faculty members for his or her scholarly excellence. We have had some phenomenal lectures in this courtroom, and we honor Austin Scott. For those here who have not heard of Austin Scott, he was a beloved teacher and scholar on this faculty for many years. And this lecture acknowledges his leadership and the level of scholarly engagement of our colleagues. What's terrific about a community lecture is we invite in the community, and in all cases, and that's particularly true this year, there is such appreciation out there. As the dean, I get the benefit of hearing from many alums about how members of this faculty have changed people's lives and how your care, concern, and engagement brings students into the scholarly enterprise, activating their professional development and their intellectual imagination has long-lasting impact. In the case of Melissa Hart, we have someone whose level of service to our community, concern for our students and the broader community, sets an extremely high bar. She has been acknowledged with the Calhoun Award, with the Chase Award, and she has continued to serve in so many ways it's hard to do justice. I think we have a bio here that tries. The level of activity she's had even in the past month is hard to keep track of. Last week she hosted Justice Scalia here and showed off her grace, intelligence, and wit in a really wonderful fashion. She hosted the Rothgerber Conference that she puts on every year as the director of the Byron White Center. If there's a person who defines the concept of being a dynamo, it is Melissa. And we are so fortunate to have her in our community, and it's so wonderful to acknowledge her and give her the floor for this Scott Lecture. Thank you, Melissa.
I'm never sure what exactly to do when someone's standing there saying such nice things about you. It feels very awkward, but thank you. And thank you all so much for being here tonight. I'm excited about sharing these remarks with you. It's an honor to be giving the Scott Lecture, and I'm also interested in throwing these ideas out there and seeing what people think of them. I want to start by explaining the title for my talk, Some Ethical Obligations of the Modern Law School. The idea, and therefore the title for this talk, and also for the larger project that it is part of, derives from three of my particular areas of interest. I've been teaching legal ethics, the ethics of the legal profession, for about 10 years now. I've also been actively engaged in discussions about the law school curriculum for at least that time. And I, like most of us in this room, I suspect, have read about and watched with concern the fundamental troubles that have beset both legal education and the legal profession since at least 2008, and frankly, long before that time. In legal ethics, and really in all of the classes that I teach, we spend a lot of time talking about what people should do. Sometimes the imperative is a legal one, sometimes a business-focused or tactical imperative, and sometimes ethical or moral. And I'm drawing a distinction here between morals and ethics in that I use the term moral to mean broadly what is right and wrong, and ethics to refer to a specifically agreed upon set of principles of conduct that members of a profession, in this case the legal profession, are expected to observe. There's no shortage today of strong opinion about what law schools should be doing. And like most problems we discuss in law school, the imperative there has multiple sources. To take what I believe is a relatively uncontroversial example, law schools should be transparent about the employment rates of their graduates. They should be transparent because the ABA accreditation rules and perhaps the law of fraud requires it. That is a legal imperative. They should be transparent because many legal bloggers out there are just waiting for a law school to be less than transparent and tear that law school to shreds. That's more of a tactical or business imperative. They should be transparent because dishonesty or lack of clarity about the prospects for employment after law school could induce some students to invest in an education that may well not lead to employment, but will certainly lead to massive debt. This last imperative is a moral imperative. It is immoral for law schools to lie or make material omissions to induce students to pay for a law school education. That moral imperative, the prohibition against dishonesty, exists external to the legal ethics rules, but it is also enshrined explicitly in them in multiple rules. I don't think there's much controversial about the idea that law schools and the individuals acting within law schools should adhere to the kinds of moral imperatives, don't lie, that generally apply to all of us. But the question that I became interested in is, are there ethical rules that apply specifically to law schools as part of the legal profession? In starting to answer this question, I quickly realized that to answer it, we have to confront another question, one that lies at the heart of much of the current crisis in legal education. Are law schools more appropriately considered part of the academy or part of the legal profession? This question has been aptly characterized by Georgetown law professor Robin West as part of the existential crisis facing law schools today. In a really superb book called Teaching Law, West writes, hopefully this might look at that, at the root of the law school's existential crisis is the simple fact that the professionals that law schools house, the faculty and administrators for whom the law school is not a station to pass through en route to becoming a lawyer, but is rather a professional home, have no shared collective sense of the reason for law school's existence, the school's teleological purpose. Do law schools exist to serve law, the legal system, or the legal profession? Or do law schools exist to serve the university in which they have been comfortably housed for the last 150 years? More prosaically, do faculties have more in common with their colleagues in history, philosophy, or political science departments, or with their peers in law firms or in the Justice Department? In her book, West goes on to discuss how this existential crisis manifests itself in our teaching and our scholarship, and in divides within the legal academy about both. I'm not going to go further into that tonight, though I highly recommend her book. Many of the proposals for reform of legal education made in recent years have been made in an effort to connect law schools more with the profession, and most of the criticisms, or many of the criticisms of law schools, center on our disconnect from the needs of the profession. I'm not really going to focus on that either. My goal in this project is not, or not primarily, to critique what law schools currently are doing, but instead to ask whether the system of legal ethics that creates obligations in lawyers and judges might also create obligations in law schools as part of the profession, and if so, what those obligations might include. While I know this may be a contestable proposition, I am, for tonight's purposes, taking as a given that law schools are and must recognize themselves as part of the legal profession much more than we have to date. So the really short answer to the question of whether the system of legal ethics creates obligations for law schools is no. Thank you, I'm done. No, I'm just joking. There's not an explicit inclusion of law schools in the rules of legal ethics. The ethical rules that govern lawyers, each state's rules of professional conduct, govern those law professors who are ourselves lawyers, but that's because we're lawyers, not because we teach law. And they say nothing about law schools. Are there other possible sources of ethical obligation for law schools as part of the legal profession, rather than as part of the university, where the American Association of University Professors' statement of professional ethics would clearly be a source? The ABA's accreditation standards might be construed as a kind of ethics code for law schools, or perhaps more accurately, the Council for Accreditation might be viewed as analogous to Attorney Regulation Council, having the responsibility to determine on a semi-regular basis whether our license, our accreditation, will be retained. But while the standards include requirements that are related to legal ethics, for example, the requirement that we offer a course in legal ethics, the requirement that we offer significant pro bono opportunities for our students, and some of the new requirements in the revised ABA standards that were approved this August about measuring outcomes in the area of professional responsibility and ethical knowledge, I don't think they're well described as an ethics code. The American Association of Law Schools does have a statement of good practices by law professors in the discharge of their ethical and professional responsibilities. This statement of good practices self-defines as largely aspirational in the responsibilities that it describes professors as having to students, to colleagues, to the law school and the university, and to the bar. In that last regard, our responsibilities to the bar, the report notes that a law professor occupies a unique role as a bridge between the bar and students preparing to become members of the bar. It is important that professors accept the responsibilities of professional status. The statement then doesn't set a very high ethical standard in general. It directs that law professors should, at a minimum, adhere to the code or rules of professional conduct of the state bars to which the law professor may belong. And it expresses the view that, with the exception of conduct undertaken to test the limits of professional rules to determine their constitutionality or scope, other conduct warranting discipline as a lawyer should be a matter of serious concern to the professor's law school and university. The one traditional area of ethical obligation that the statement does elaborate on is the obligation enshrined in the rules for lawyers in 6.1 to engage in pro bono representation. And as to that, it actually does provide a slightly higher standard, stating that as role models for students and as members of the legal profession, law professors share this responsibility. The fact that a law professor's income does not depend on serving the interests of private clients permits a law professor to take positions on issues as to which practicing lawyers may be more inhibited. With that freedom from economic pressure goes an enhanced obligation to pursue individual and social justice. And that's really it in terms of what's out there about ethics codes that might be applicable to us as members of the legal profession. Does this rather limited set of legal ethics provisions explicitly applicable to law schools or law professors mean that our ethical obligations as part of the legal profession are similarly limited? I don't believe so. The larger project that forms the basis for this talk, as I mentioned, is an effort to define the range of legal obligations that legal ethics obligations that might apply to law schools as institutions and law professors as individuals. For the remainder of my time this evening, though, I want to turn to two specific examples currently garnering a great deal of attention in discussions about reform: the access to justice crisis and the concept of the practice-ready lawyer, and to suggest some ways, as you'll see very different ways, that the ethical obligations of law schools might play out in these two areas. So first, access to justice. The massive access to justice gap, which leaves unmet the large majority of the legal needs of most Americans, is one of the most significant challenges facing the legal profession and the system of justice today. In 2011, the United States was ranked by the World Justice Project as 50th out of 66 developed nations in providing accessibility to its civil justice system. The legal system and legal representation are simply beyond financial reach for most Americans. The available data on the scope of this justice gap is remarkably spotty. We have some data for low-income households, people living at 125% of the poverty line, which, for those of you who don't know, for a family of four in 2014 means a household earning $29,800 or less. These low-income people are eligible to receive civil legal aid from Legal Services Corporation-funded organizations like our Colorado Legal Services. So there's some structure in place for collecting data about their needs and the ability of legal aid lawyers to meet their needs. In 2007, the Legal Services Corporation reported that there was, as a national average, only one legal aid lawyer for every 6,415 income-eligible Americans. And this compared with one lawyer doing civil work for every 429 Americans in the general population, a really significant difference. As of this year, in Colorado today, there is one legal services lawyer for every 18,278 Coloradans eligible to receive assistance from Colorado Legal Services. It's more difficult to find data about the number of lawyers serving the vast majority of the population that is not poor enough to receive assistance from legal aid foundations, but not wealthy enough to pay hundreds of dollars an hour for legal assistance. But these moderate income clients, now referred to in the literature as gap clients because they fall in that gap between the poor and the rich, are a large and growing segment of the population, and there is little evidence to suggest large numbers of lawyers are currently available at rates that they can afford. Now, someone skeptical about the need for lawyers might say that these numbers are just fine. The fact that there are fewer lawyers serving lower income clients is only a problem if these clients have unmet legal needs. A now slightly dated 1994 study by the ABA is the most comprehensive nationwide examination of that question. In this study, researchers interviewed people from households across the range of the bottom 80% of income earners nationally. More than half the respondents described circumstances that presented serious situations involving civil legal problems, but most, well over half, had either tried to handle the problems themselves or took no action at all. These results are consistent with more recent studies. In 2009, Legal Services Corporation reported that about 1 in 5 legal problems of low-income people are addressed with the help of a lawyer. Inadequate funding for legal services providers like Colorado Legal Services forces those organizations to turn away about half of the requests for assistance that they receive from income-eligible people with real legal issues. The legal issues that these low and moderate income people need help with are wide-ranging. As UCLA law professor Luz Herrera, a pioneer in evaluating how best to support lawyers committed to what we now refer to as low bono, or modest means practice, explains the legal problems of average income Americans include asset distribution at divorce, bankruptcy advice when they experience financial ruin, child custody issues and estate matters when family members die. Past studies and recent trends reveal that individuals need lawyers to help them navigate legal issues that involve contract breaches, consumer matters, housing issues, workplace problems, government benefits, domestic relations, immigrant status concerns, and legal considerations of self-employment, among others. When people can't get legal assistance with these problems, they either take no action, which generally leads to increasingly serious problems, or they try to self-represent. In Colorado, as an example, more than 50% of civil litigants are self-represented. And in family law, more than 76% of family law litigants are self-represented. But that's not necessarily a problem. Self-representation isn't always bad, and in fact, we're doing a lot to support self-represented litigants today. But given the complexity of the law and of legal problems and navigating the legal system, self-representation is a daunting prospect for most lay people. In the ABA's 1994 study, among low-income people who tried to solve their problems on their own, 27% were satisfied with the outcomes. For moderate income people, that percentage was about 40%. Among people who received legal assistance with their problems, the number of satisfied low-income people rose to 48% and moderate income people to 64%. So representation sometimes really does make a difference. Moreover, the burdens of self-representation do not fall only on the parties. Last fall, the Colorado Access to Justice Commission held hearings around the state to assess the access to justice circumstances in Colorado. Judges and clerks uniformly reported that self-representation slows the legal process and puts judges in uncomfortable situations given their responsibility to remain neutral, even in the face of situations where some legal advice is clearly needed. The access to justice problem is not a new one, but it is a worsening one. And it is one for which the legal profession has a special responsibility. We are a largely self-regulated profession with a monopoly on the provision of legal services. Recognizing that fact, the rules of professional conduct, and here I'm going to quote Colorado's rule, but every state has some variation on this, provide that a lawyer should be mindful of the deficiencies in the administration of justice and of the fact that the poor, and sometimes persons who are not poor, cannot afford adequate legal assistance. Therefore, all lawyers should devote professional time and resources and use civic influence to ensure equal access to our system of justice for all those who, because of economic or social barriers, cannot afford or secure adequate legal counsel. The statement from the preamble is reinforced in Rule 6.1, which provides that every lawyer has a professional responsibility to provide legal services to those unable to pay. What ethical obligation does this suggest for law schools? Well, we are a gateway to the legal profession. As a 1986 report published by the ABA Commission on Professionalism noted, the law school experience provides a student's first exposure to the profession, and professors inevitably serve as important role models for students. Interestingly, the AALS Statement of Good Practices by Law Professors focuses on that role model status in specifying that law professors should be doing pro bono and public service work. Not only do we as professors serve as role models, but the law school experience is pivotal in shaping the values of those entering the profession. As then Chief Justice Warren Burger wrote in 1980, "We know full well that the law school is an immensely powerful force in defining, structuring, and internalizing professional norms, values, and attitudes. The law school is uniquely situated to shape and form the habits of students during the period in which their professional ideals and standards of ethics are being formed." In recognition of this reality, many, indeed really most, recent proposals for reform of legal education have highlighted the urgent need for law schools to help students with the development of professional identities and a sense of professional responsibility. This development of professional identity should include an understanding of each lawyer's obligation to, as the preamble provides, devote professional time and resources and use civic influence to ensure equal access to our system of justice. Indeed, the obligation to help students develop competency in the exercise of proper professional and ethical responsibilities to the legal system, in addition to our clients, was emphasized in the revisions to the ABA accreditation standards that were approved this August. But I believe it is more than simply an accreditation hurdle. The role of law schools as part of the legal profession, as well perhaps because of the role of law school tuition in making legal services so expensive, obligates us to participate actively in addressing the justice gap. How should law schools fulfill this obligation? I think one of the ways that we clearly do, and probably the best way that we do or can, is through the operation of our legal clinics. I'm going to take that as a happy given and talk about a couple of other ways that we could think about in addressing the justice gap. One is through offering students pro bono opportunities, which again we're actually required to do by accreditation standards. Some recent proposals from the bench and bar, as well as from the academy, have advocated for pro bono service as a law school graduation requirement. For example, in 2013, the National Conference of Chief Justices passed a resolution providing that the Conference of Chief Justices encourages the Chief Justice of each state to discuss with the deans of their law schools a proposal that students perform pro bono service prior to law school graduation as a condition of admittance to the state bar. This proposal followed from the 2012 announcement of New York's chief judge that that state now requires completion of 50 hours of pro bono service as a condition of admission to the bar. A proposal to make a pro bono graduation requirement part of the accreditation standards was also considered by the ABA this year, but was rejected. A growing number of schools has nonetheless adopted a pro bono or public service graduation requirement on their own initiative. As of June 2014, 41 law schools had pro bono or public service graduation requirements, and another 125 additional schools had adopted formal voluntary pro bono programs. As some of you know, I have generally been a very strong advocate of mandatory pro bono programs. That's something I think would be a good policy. But recent research actually has adjusted my sense of what we should be doing. Recent research has shown that whether a law school program is voluntary or mandatory doesn't really have a correlation with whether graduates will go on to do pro bono work as lawyers. And since I think a big part of why we should be encouraging students to do pro bono is to inculcate in them a sense of that obligation to be doing it, we should be judging the effectiveness of our pro bono programs against that measure. How well are we succeeding in encouraging students to become lawyers who will do pro bono work and contribute to access to justice? In that regard, for encouraging students to become lawyers who do pro bono, what seems to matter most is whether the experience the student has with the pro bono work is positive or negative during law school. Stanford Law professor Deborah Rohde, who has done extensive research on these questions, has found that positive pro bono experiences result from programs in which the value of pro bono service is reflected and reinforced throughout the law school experience in both curricular coverage and resource priorities. So again, it's not so much do we make everyone do it or do we ask everyone to volunteer, but it matters a lot how universal it is in how we talk about pro bono and also how much we're willing to provide resources to support it. And I think that's something law schools should be doing. In addition to robustly encouraging pro bono service, law schools could and should be doing more to encourage students to consider and successfully pursue legal careers representing modest means clients. We could do that by providing more career counseling in this area and offering more law practice management courses that include discussions about the delivery of modest means legal services. We could do that by offering loan forgiveness or scholarship opportunities, not only for students who go into public service work, but also for students willing to serve the basic legal needs of rural communities, which are currently dramatically unmet. The most recent ABA journal was actually all about the unmet needs of rural communities all over the United States. These are generally modest means needs, and the practices in those areas would generally be modest means practices. Many schools, Colorado law included, are implementing efforts to these ends. A more ambitious approach to the justice gap for average income Americans that a growing number of law schools are considering is the creation of law firm incubator projects. These incubator projects, also sometimes called residency programs or law firm launch pads, are designed to assist recent law school graduates to develop viable modest means practices by providing young attorneys with practical training and mentoring on substantive law, as well as free or subsidized office space, legal research resources, and malpractice insurance, which are among the most expensive aspects of setting up a practice. These efforts have been actually around for several decades. The first such effort was the Law School Consortium Project, which was launched by a group of 4 law schools in 1997. But the number of incubator projects has been expanding rapidly in the past 2 years. As of today, the ABA's Standing Committee for the Delivery of Legal Services lists 29 legal incubator projects, most of them created through partnerships between law schools and local bar associations. Half of those programs started within the past year, and it seems likely that we will see even more incubator projects in the near future. In August, the ABA House of Delegates passed a resolution urging bar associations and foundations, courts, law schools, legal aid organizations, and law firms to create and advance initiatives that marshal the resources of newly admitted lawyers to meet the unmet legal needs of underserved populations in sustainable ways. Incubators are an intriguing option for many law schools and bar associations, not only, possibly not even primarily, because they develop attorneys with a willingness and skills to represent average income Americans, but also because they provide career opportunities and practical training for recent graduates in today's tough legal economy. They assist in the development of the practice-ready lawyer. That is my very clean segue to my second topic, the practice-ready lawyer. Demands from the practicing bar and from many law students for law schools to graduate practice-ready lawyers are ubiquitous. Many law schools have responded to the call with robust marketing campaigns, and most have responded with some amount of curricular reform. The ABA's new accreditation standard will require all law schools to ensure that their graduates receive a minimum of 6 credits of experiential coursework to graduate. My intention this evening is not really to debate the merits of the concept of a practice-ready lawyer, but I have to pause for a moment to say that I think it is a flawed concept in that it suggests both that there is a moment when a lawyer can be identified as ready to practice, and also correspondingly that a practicing lawyer is not in constant need of growth and training. In fact, as is well expressed in the Colorado Supreme Court's rules on continuing legal education, the public rightly expects that practicing attorneys in their practice of law and judges in the performance of their duties will continue their legal and judicial education throughout their period of service to society. As the ABA Commission on Professionalism recognized in 1986, the education process is an ongoing one for which all segments of the profession, not just the law schools, must take responsibility. The recent task force on the future of legal education similarly recognized that it is a mistake to place the entire obligation of educating lawyers onto law schools. The need for lifelong learning throughout a legal career is reflected not only in continuing legal education requirements, but also in the increased emphasis on the educational benefits of mentoring relationships within the profession. These are important aspects of legal practice, but they are in uncomfortable tension with the notion that when you leave law school, you should be practice ready. That said, I think many of the curricular reforms and discussions that have resulted in part from calls for practice-ready lawyers have been really positive. I'm not going to talk about the positive ones, though. Some are more troubling and raise really significant ethical concerns. In discussing the justice gap, I explored how the preamble and Rule 6.1 might be relevant to an assessment of our law school ethical obligations with regard to pro bono. In discussing the trends that have occurred in our pursuit of the practice-ready law grad, I am turning to provisions of the rules of professional conduct that prohibit a lawyer from advising a client to engage in conduct that is criminal or fraudulent, and that require a certain level of professional honesty from the lawyer herself. In legal ethics classes, we spend a lot of time discussing how lawyers need to make a living can create very real and very difficult conflicts with the obligations the lawyer has to represent her client. And we talk through at length how a lawyer should navigate those conflicts in a principled way. It's really the hardest part of legal ethics. Law schools face analogous conflicts when we puzzle through how to offer the best education we can to our students in cost-effective ways. One of the real challenges that law schools are facing today is that much of the skill-developing education that law students and the bar are clamoring for is also some of the most expensive, or at least it is expensive if it is done right. And no one thinks that raising law school tuition would be either ethical or tactically wise. This dilemma is about to become even more real for many law schools because of the ABA's new accreditation standards. We will have to confront the challenge of incorporating additional experiential classes into our curriculum. Of course, some law schools will likely meet the requirement by simply designating a lot of courses as meeting the requirement without adding or changing anything. I think that approach evades the spirit of the change, but it also avoids the cost of offering more experiential opportunities. Some schools will avoid the cost issue by permitting students to spend more essentially unsupervised hours outside of the building. It is this latter approach that I fear presents significant ethical risks of which we must be vigilant. Legal externships can offer law students great learning opportunities, and I am not here suggesting a wholesale criticism of the externship model, but I do think that we have to be careful in thinking about whether, how, and when we expand externship credits. Permitting students to earn experiential learning credits through externships is definitely cost-effective, but as two externship advisors writing about how to develop cost-effective programs recently noted, even when the externship is providing a great learning experience for the student, there is something intuitively wrong with charging a student full tuition for an experience taking place away from the law school that is primarily supervised and in most respects dependent on experienced lawyers and judges who are not charging the law school anything for their service. Charging the student full tuition for externship experiences becomes even more problematic when we consider how difficult it is to truly oversee the value of the learning experience offered by an externship. And yet, the more law schools require externships to have robust in-building learning components, the less attractive those externships are to students. And the more we require significant oversight and submission of written work, the less attractive they become to many employers. These concerns apply to all externships, whether they're with a judge, whether they're with the government, whether they're at a private law firm. There is a separate, and to my mind, more troubling ethical concern, which has arisen significantly in recent years as schools have struggled to help their students find employment in a tight legal market. So I'm going to try not to go too deep into the woods of the Fair Labor Standards Act here, but I have to explain a little bit about it. The Fair Labor Standards Act is the law that requires all employees of for-profit employers. It doesn't apply to the government, and the Secretary of Labor has interpreted it not to apply to nonprofits, but requires for-profit employers to pay their employees a minimum wage and to provide overtime for more than 40 hours of work in a week. There are some exceptions to this requirement, and one of them is an exception for what the Wage and Hour Division of the Department of Labor calls trainees. In 2010, the Wage and Hour Division of the Department of Labor released a fact sheet to address concerns that had arisen about when interns, which is what an extern is, we just call it an extern, but when interns are employees and when they are trainees. The fact sheet describes a multi-factor test for making this determination. All of the factors must be met in order for an intern to qualify as a trainee. Among other factors, the Wage and Hour Division includes the following two that present, I believe, a significant challenge to law school externships at for-profit placements. The intern must not displace regular employees, but must work under the close supervision of existing staff, and the employer that provides the training must derive no immediate advantage from the activities of the intern. The wage and hours division's fact sheet goes on further to explain, to elaborate, if an employer uses interns as substitutes for regular workers, or if the employer would have hired additional employees or required existing staff to work additional hours had the interns not performed the work, then interns are employees entitled to minimum wage and overtime pay. On the other hand, if the employer is providing job shadowing opportunities that allow an intern to learn certain functions under the close and constant supervision of regular employees, but the intern performs no or minimal work, the activity is more likely to be viewed as bona fide education experience. Externs work at law firms because the law firms then don't have to ask the practicing lawyers to do the work. Law firms wouldn't hire externs if they offered no benefit to the law firm. And frankly, I don't think students would be as interested in externships if they did no or minimal work and only shadowed lawyers. So what we're doing with law school externships is directly in tension with these rules. But despite these concerns, as of 2012, a majority of American Association of Law School member schools, 96 out of 200 and some, 54.5%, permitted placements in for-profit externships. Among the 96 law schools that had permitted for-profit externships, however, there was a great deal of variation in the scope of work permitted. In particular, some law schools have drawn a distinction saying, we think it's permissible if law students are working as externs doing pro bono work, so not doing the billed work of the law firm. A number of schools, though, in recent years have started to change their policies in both directions, some saying we're uncomfortable with this as a legal and ethical matter, and some saying we need to do this to get our students jobs. This issue of Fair Labor Standards Act coverage of law school externships looked like it would actually be resolved in 2013 when ABA President Laurel Bellows wrote a letter to the Solicitor of Labor asking for clarification as to whether law firms that employed unpaid student interns to do pro bono cases would be in violation of the law. In framing her question to the solicitor, Bellows assumed that the placement of unpaid interns in law firms to do work for paying clients would violate the Fair Labor Standards Act. Her letter is focused on the concern that even law firm placement to work on pro bono cases might be interpreted as illegal, and she was seeking clarification of that question. Solicitor of Labor Patricia Smith responded to the ABA query about a year ago in September 2013. Her response confirmed that a law student could do pro bono work with a private firm so long as the student was under close and constant supervision from the firm's licensed attorneys and the extern did not participate in a law firm's billable work or free up staff resources for billable work that would otherwise be utilized for pro bono work. However, a law student would be considered an employee subject to the Fair Labor Standards Act, where he or she works on fee-generating matters, performs routine non-substantive work that could be performed by a paralegal, receives minimal supervision and guidance from the firm's licensed attorneys, or displaces regular employees, including support staff. Somewhat to my surprise, frankly, law schools have struggled with how to respond to this exchange. Some read it as a clear statement that for-profit placements for anything other than pro bono work are not permissible. Others have fastened onto sentences in Solicitor Smith's response that seem to open the door for non-pro bono placements so long as the externships are structured in ways that highlight their educational elements and provide little real benefit to employers. And still others have concluded that even pro bono placements risk violating the law, given that work done by an unpaid student intern does generally free up resources that the law firm would otherwise dedicate to the pro bono matter. So at this point, you may be wondering what any of this FLSA stuff has to do with the ethical obligations of the modern law school. You may also be thinking that it's time for me to stop talking. I'm going to try to address both thoughts quite quickly. As to the first, here it is. The business pressure on law schools to offer for-profit externship placements is significant. Law students want us to do it, law firms want us to do it. But doing so permits students and law firms to enter into employment relationships that violate the law. It is analogous to advising clients to break the law, and it is, I believe, counter to our ethical obligations and responsibilities to the profession and to the students. Of course, law professors, and therefore I think we can say law schools, are permitted to test the limits of the law in an effort to ascertain its proper application. If a law school that believed that the solicitor of labor has left open the possibility for for-profit placements doing work that is not pro bono wanted to ask the solicitor for clarification of the issue, it could certainly do that. But to keep our heads down and trust that these programs won't be challenged is a poor professional choice. It's a choice that is particularly troubling given that many of our moral, ethical, and pedagogical obligations to our students flow directly from the role of law schools and individuals within law schools as the first legal professional role models that most law students will see. The obligations that flow from that role are at the center of how the rules of legal ethics should, and I think do, apply to law schools as part of the legal profession. Thank you. At my kids' school, they do these morning presentations, and then after they do their presentations, they say, "Any questions or comments?" So I feel like that's what I should say now. Any questions or comments? They always say it with that little lilt. Yes?
Just regarding the externships, you mentioned the experiential learning requirement of the ABA, but also the issues with unpaid externships. But with law school rules currently, a student can't get an externship credit if it's paid. Do you think that law schools with these new rules and laws are going to have to reevaluate how they go about their system of awarding credit? And are there any ethical concerns with that, especially when you do have some clinics, I don't necessarily know about CU's clinics, but that do have an income source? Does that mean that clinics will have to start paying their students as well?
No, well, clinics are a completely different animal because they're part, I mean, particularly if we're thinking about CU's law clinics, we're part of a public institution. And so there are a couple of different things to separate out there. The Solicitor of Labor has not applied the same rules about externs to government employment or employment in nonprofit organizations, which there's no real legal basis for making that distinction, but they've drawn that distinction and said that's how they're enforcing it. So externships that are at not-for-profit or government organizations can be done not for pay and therefore for credit. So there's no, and that's what CU does. CU doesn't offer, just to be clear, I should have said this, we don't offer externship opportunities in for-profit firms because it violates the law. So we've made a decision to hold that line. But we do offer externships in for-profit, in not-for-profit and government because that doesn't violate the law. As to the accreditation rule about offering credit, or not offering credit rather, for paid work, that rule was also debated by the ABA at length this summer, and ultimately a change that would have permitted credit for work for which you're also paid was rejected. And so that rule is not going to change anytime soon. And you think it shouldn't have been rejected, huh? The reasons for that, I mean, there was a lot of debate about that, but the reasons for holding the line and saying if you're going to, we should only be awarding credit for work that you're not getting paid for, is that the hope with a legal externship is that the motivation for doing it is educational, and that's our goal, right? We want to be running externship programs where the reason you're doing the externship is to learn something about practicing law. Once you add financial remuneration into the picture, then that primary goal of learning something about the practice of law risks being subsumed or overwhelmed by the opportunity to earn money. That's the concern that motivated the rejection of that change. And I think since the ABA just considered it, I can't imagine they'll reconsider it again anytime soon.
Mandatory and voluntary pro bono pledge programs, and it looked like mandatory voluntary didn't make much of a difference, but a good experience did. Is there more information about what counts as a good experience, and is it one, is it many? You also talked about this idea of sort of
multiple.
Yes.
So there are several different studies that have tried to look at what constitutes a good pro bono opportunity, and frankly, not just a good pro bono opportunity. One of the interesting things is that many of the studies show that the people who are most likely to go on and do pro bono work after they graduate from law school are actually people who participated in clinics, which is not pro bono work because that's work for credit, and so that's generally considered not pro bono work, although it's also serving people of modest means. But the kinds of things that supervision is a big piece of it, which again connects, I think, to why clinics are really successful in terms of giving people good experiences. But having some kind of supervision, having a sense of not sole accountability. When you read about interviews with people who had bad pro bono experiences, they tended to be experiences where someone was thrown into something completely out of her or his depth and felt that they were either making things worse or weren't sure how to make things better. So that piece seems to be a big part of it. And then I think the idea that pro bono and commitment to pro bono is emphasized throughout the curriculum, that it's viewed as just part of the norm of the legal profession, is something that just makes it less controversial. This is what we do. And that tends to increase people's satisfaction with the experience. Yes?
So you talked a little bit about the access to justice crisis, and I wonder if you could explore the connection between what law schools are doing and whether you think it's going to actually result in the type of pro bono work that would meet the needs, and map onto that the economic situation that the United States has been in, and talk about, realistically your prediction for what we might start to see.
Okay. So, I think what law schools are doing in terms of seeking to meet the needs of low-income people, both through clinics and through pro bono projects. And one of the things that's really interesting to see, and we see it here at Colorado Law, we've increased the number of faculty-supervised pro bono opportunities dramatically in the past several years, and that's happening at lots of law schools. That seems to be a really popular form of program. It's not quite a clinic, but it's not just put it up on CD online, you could go help someone, but actually, again, have the supervision. That seems to be making a big difference in terms of meeting specific legal needs, again, because the supervised opportunities provide a chance for the supervisor to assess where legal needs could best be met. And so the targeted opportunities are more effective in that context. In terms of modest means representation, which I really think is probably the larger challenge that the legal system is ultimately facing today, I think the jury is very much still out on whether these legal incubator projects are going to end up being able to really do what they hope to do, which is to develop a strong crew of people who are committed to, and again, can successfully come up with an economic model that allows them to represent modest means clients and still make a living. The massive number of, or massive attention in legal scholarship and in legal aid organizations and conferences to really seriously digging down into what an economic model for a modest means practice would look like. It's just been huge in the past couple of years. And so you'll see, you now see law review articles that instead of just saying, we should represent modest means people, we should have modest means practices, you'll see articles that say, this is what a budget would look like in California for someone living in Los Angeles. Here are the things you'd have to pay for to run a legal practice. Here are the things you need to live on, you need to survive. Here's your law school debt. How can we put all of these things together and make it work? So I think that kind of deeper and more careful analysis and then ultimately assistance to students will probably make some difference. But I also think that the range of needs is so huge, and the challenges because of law school debt, because of the costs of litigation. It's not, one of the things that's really complicated when you start to look at trying to solve some of these problems is we could lower lawyers' fees significantly, but the cost of filing something in court keeps going up and up. And so for a modest means client, it's not just a question of, is the lawyer charging too many fees? It's really a question of how do all of these things work out to make it viable to pursue litigation or alternatives to litigation. So I'm not sure that I think we will be able to, I don't think we'll ever be able to address all of the unmet legal needs. I think that will always be a problem, but I think we could do much more than we have to date. Scott?
Two questions. think this is great, and I think the question you started with of, in what ways do the legal ethics rules apply to us, is a great question. So I have two questions. One is, do you think professors in law schools, at least professors in law schools who have a JD, should have an active license in the state in which they're teaching? And two, legal ethics rules are relatively easy to change. They're not easy to change, but they're easier than some other things to change. The state of Colorado, we could change the Colorado ethics rules and write a rule acts that apply to the law schools active in this state. Were we to do that, and I know some judges there who would probably do it, and you do too, what would that rule say? I mean, what if we wanted to go at this head on and say, look, we're going to start regulating these entities as part of our general professional oversight. What might such a rule say?
So the answer to your first question is yes, I do think so, but that's even more contestable than lots of other things. Many people don't think so, but I think that law professors in general should be licensed in the state in which they're teaching. And Colorado, among other states, makes it so easy. There's a special rule that law professors who are teaching at either DU or CU can become members of the bar without taking the bar, and can be members of the bar for as long as they're teaching. So it's expensive, but it's easy. In terms of the second question, I mean, it's one of the things that's challenging is, if you will note that the only provisions that I could cite to about pro bono are the preamble and Rule 6.1, which very specifically is not mandatory, but it is, the title to Rule 6.1 is voluntary pro bono service. We have, as a legal profession, never been able to get behind anything more than aspirational requirements to either do pro bono, or I think it really important that the rule provides a lawyer should voluntarily contribute financial support to organizations that provide legal services to persons of limited means. So you don't necessarily have to do pro bono, but you should be contributing to meeting these legal needs. So the idea that we would have a rule that said law schools should be involved in this process somehow, on the one hand seems pretty easy, because as you say, legal ethics rules are easy to change, and chances are good that any rule that involved law schools and pro bono would be similarly entirely aspirational, and so would be not that scary to pass. But I'm not sure that I think it would. I think the ABA rules and AALS rules that address pro bono kind of address that, so I'm not sure how much difference it would make to have a legal ethics rule with regard to pro bono. And with regard to other things, I'm still sort of sorting that out. I think I'm not convinced that it makes sense to have the rules of professional ethics specifically address law schools. And so my thought experiment in this project is more maybe looking at the penumbra of the ethics rules and asking, where do they intersect with our obligations? Kristen?
Thanks so much. I love this talk, and I love the encouragement that I feel like it gives us as law professors to remain engaged in pro bono work. When we do that, and when I do it, how should I think about issues like professional liability insurance, conflicts with respect to my own responsibilities and students that I'm supervising?
So professional liability insurance, I somewhat depends on where you're doing your pro bono work. If you're doing any of it through like a legal services organization like Metro Volunteer Lawyers, they provide the professional liability. So you're covered there. You don't need to worry about it yourself. In terms of anything that we would do just independently, I think that is complicated because I think, I'm looking at Deb Cantrell because she can tell me if I'm wrong, but I think I'm right that the clinic's professional liability insurance would not cover those of us not working in the clinic.
The university's risk management policy covers all of us.
Ah, there you go. So I think the professional liability piece is a good one to think about though, because obviously, I mean, that could be serious if there wasn't coverage. In terms of conflicts, I think, so the AALS rules that talk about, not so much where they talk about pro bono, but they talk about doing outside service, being engaged outside of the university, and specifically say, although I think they're a little vague about what they're talking about, but I think they might be talking about compensated external service, like earning money doing research projects and things. But they specifically do say we need to be vigilant that we're not abdicating our responsibility to our students and our duties inside the building, that's a conflict we have to avoid. In terms of conflicts in the straight legal ethics sense of conflicts, I think it's the same thing that any lawyer would have to do. Just look at whether there are any conflict in terms of personal interest or other clients that would affect the representation in a way that's impermissible. Rick, did you have, yeah?
You said that you recited a statistic that we rank very low as a nation in legal access. So that implies a bunch of other countries have solved this problem better than we have. And I can readily suppose that a more robust public sector is one of the reasons. Putting that aside, is there any evidence that some other country really does legal education in this department better than we?
No, or at least I haven't seen anyone talking about that. So that's actually one of the things that I also was wondering about, whether there's something different about the way lawyers' obligations are talked about, or the way law schools, law schools are pretty American concepts, but university law departments talk about access that might be different, and I haven't seen anything to suggest that. So, but I do think it's an interesting question.
Time for one more question.
Yes?
My comment goes towards your remark that one of the goals of graduating practice-ready lawyers, or students, practice-ready. And I'm a big believer in mentoring. I'm a practitioner for a long time. And have you thought about, or others thought about, linking experienced practitioners with your law students in the shadowing time, and the carrot being CLE credit?
Yes. Would you like me to elaborate? Well, so yeah, so there actually, this is the Colorado Supreme Court's Chief Justice's Commission on the Legal Profession last year established a new program that now is part of the CLE rules and also part of the attorney registration rules in Colorado, for a program called the Colorado Attorney Mentoring Program. And if you participate specifically in that program, not all forms of mentoring, but specifically in that program, which has a set of requirements, you can get CLE credit for it, pretty significant amounts of CLE credit, actually, both as a junior lawyer and as a senior lawyer. And after that was established, we set up a program here that did rather than a two-way partnership of a junior lawyer and a senior lawyer, set up a three-way mentoring team of a law student, a junior lawyer, and a senior lawyer to meet and, again, go through. There's a fair amount of education that's required. We required the participants in our project to actually do a pro bono project together, so that with the idea that the most robust mentoring happens when you're actually engaging in the practice of law together. And it worked really well. It's hard, though, to sustain those programs without massive amounts of administrative support and many people herding cats. And that's been a challenge, but it's still out there, and it's still something that a fair number of lawyers are participating in.
So I want to thank you for a very intellectually stimulating